For centuries, Roman law grew wild, layered, contradictory, and impossible to master. By the 6th century, justice depended on memory, privilege, and power. Then one emperor made a radical decision. He would erase the past, rewrite the law, and decide, once and for all, what justice meant. Chapter 1. Rome drowning in its own laws. By the 6th century, the Roman Empire was governed by a legal system that had grown massive, fragmented, and increasingly unmanageable. Roman law was not a single code but an accumulation, nearly 1,000 years of senatorial decrees, imperial constitutions, juristic opinions, and local rulings layered one on top of another. Laws issued under Augustus still circulated alongside decrees from Diocletian and Theodosius. Many directly contradicted each other. Others applied only to certain provinces, professions, or social classes. No central mechanism existed to resolve these conflicts. Judges were expected to navigate this legal inheritance using private collections, incomplete archives, or personal legal training. Outcomes depended less on consistency than on which text a magistrate considered authoritative. For ordinary subjects of the empire, the law was largely inaccessible. Legal Latin was technical and specialized. Written rulings were scattered across scrolls and codices few could consult. Justice often favored those with education, wealth, or connections to trained jurists. This legal confusion was not merely inconvenient, it was dangerous. Roman authority rested on the idea that law was universal, rational, and superior to arbitrary rule. When courts delivered inconsistent judgments, that legitimacy eroded. Provincial governors exercised broad discretion. Corruption flourished where clarity was absent. Even imperial commands could be ignored if an older or conflicting law could be cited in opposition. By Justinian's reign, the problem was widely recognized. Legal uncertainty undermined taxation, property rights, inheritance, military discipline, and religious enforcement. An empire that claimed to rule through law could not function when no one could say with certainty what the law was. Order itself had become unstable, created by a law, but threatened by its collapse. Chapter 2. Justinian. Power, ambition, and control. Justinian I came to the throne in 527 CE, inheriting an empire that still called itself Roman but no longer resembled the unified state of earlier centuries. The Western Empire had collapsed. Decades earlier, Italy, North Africa, and much of the Western Mediterranean were ruled by successor kingdoms. What remained was an Eastern Empire centered on Constantinople, wealthy, bureaucratic, and deeply conscious of its Roman identity. Justinian did not see himself as a regional ruler. He saw himself as a Roman emperor in the fullest sense, responsible for restoring order, unity, and authority across the imperial world. This ambition was expressed in the concept of renovatio imperii, renewal of the empire. Justinian pursued it through military reconquest, religious conformity, and legal reform. Law was central to this vision. Roman emperors had long been lawmakers, but Justinian treated legislation as an instrument of control. A clear, unified legal system would not only administer justice, it would reinforce the emperor's position as the ultimate source of authority. Christianity shaped this worldview. Justinian ruled as a Christian emperor who believed that earthly order reflected divine will. Disorder, whether legal, religious, or political, was not merely inefficient but morally wrong. Law, in this framework, became a means to impose both discipline and orthodoxy. Reforming Roman law was therefore not a technical exercise, it was a political act. By redefining what the law was, Justinian could redefine how power flowed through the empire. Courts, governors, bishops, and citizens would all be bound to a single, emperor-approved version of justice. For Justinian, order did not emerge from tradition or debate. It descended from the throne, written into law, and enforced across the empire. Chapter 3. The Impossible Project. Codifying. 1,000 years of law in 528 CE, Justinian launched one of the most ambitious legal projects in recorded history. He appointed a commission of jurists led by Tribonian, a senior legal official known for both his expertise and loyalty to the emperor. Their task was unprecedented: to collect, review, and reorganize the entire body of Roman law accumulated over nearly a millennium. This included imperial constitutions, senatorial enactments, and the writings of Rome's most influential legal scholars, some dating back to the late Republic. The scale of the undertaking was immense. Legal texts existed in multiple versions, often incomplete or corrupted by copying errors. Many laws had been revised, contradicted, or quietly ignored over time. The commission was expected not merely to compile these materials, but to reconcile them, to remove contradictions, eliminate redundancies, and resolve ambiguities. Justinian demanded speed. The first stage of the project was completed in just over a year, a pace that left little room for prolonged debate. To meet this deadline, the commission was granted extraordinary authority. They were allowed to cut passages, merge laws, alter wording, and reinterpret earlier rulings to produce a coherent system. Juristic opinions that conflicted with imperial priorities could be excluded or reshaped. This was not neutral preservation. It was active construction. The process raised fundamental questions about the nature of law. Roman legal tradition had long valued the accumulated wisdom of past jurists and the gradual evolution of legal principles. Justinian's project broke from that model. Law would no longer grow organically through interpretation. It would be stabilized, fixed, and finalized by imperial decree. The result promised clarity and uniformity, but at a cost. In resolving centuries of legal disagreement, the commission also erased alternative interpretations. The empire would gain a single legal voice, but it would speak only with the authority the emperor allowed. Chapter 4, the Codex, rewriting imperial power. The first major product of Justinian's legal reform was the Codex Justinianus, issued in 529 CE and revised in 534. Unlike earlier private compilations, this was an official, state-authorized collection of imperial legislation. It gathered centuries of emperors' laws, rescripts, edicts, and decrees into a single, unified text that was declared legally binding across the empire. The purpose of the Codex was not merely organization. Its compilers were instructed to remove laws that were obsolete, contradictory, or no longer aligned with imperial policy. Statutes that conflicted with Christian doctrine, challenged imperial authority, or reflected outdated administrative practices were eliminated. Others were modified to fit contemporary priorities. What remained was a carefully curated version of imperial law that presented consistency where none had previously existed. This process fundamentally altered the nature of Roman legal authority. In earlier centuries, emperors were powerful lawmakers, but their decrees existed alongside senatorial tradition and juristic interpretation. Under Justinian, imperial legislation became supreme. The Codex made clear that the law flowed directly from the emperor, not from custom or collective legal reasoning. The implications were immediate. Judges were instructed to rely exclusively on the Codex when interpreting imperial law. Older collections were invalidated, legal debate narrowed, replaced by reference to an authorized text. The emperor's will, expressed through legislation, became the final standard of justice. In presenting law as unified, rational, and permanent, the Codex Justinianus strengthened imperial control. It transformed law from a shared tradition into a centralized instrument of governance. Roman authority was no longer sustained by memory or precedent, but by an official text, written, approved, and enforced in the name of the emperor. Chapter 5, the Digest, Law. Filtered through elite minds. If the Codex established the emperor as the supreme lawgiver, the Digest went further, reshaping how Roman legal thought itself would be remembered. Completed in 533 CE, the Digest, also known as the Pandects, was the most ambitious and controversial element of Justinian's reform. It condensed centuries of juristic writing into a single, authoritative compilation, intended to guide judges in legal reasoning, not just statutory reference. Roman law had long relied on the opinions of jurists, elite legal scholars whose interpretations shaped court decisions. Figures such as Ulpian, Paulus, and Gaius represented different schools of thought, often disagreeing on fundamental principles. Their debates gave Roman Law its flexibility. Justinian's commission drew from these works, but it did so selectively. Out of an estimated 3 million lines of legal writing, roughly 150,000 were preserved. The process was not neutral. Passages were shortened, merged, or altered to remove contradictions. Jurists whose views conflicted with imperial policy or Christian morality were minimized or excluded. Even within surviving texts, wording was adjusted to align with Justinian's legal priorities. The resulting digest presented the appearance of consensus where disagreement had once existed. Once issued, the digest carried the force of law. Judges were forbidden from citing any juristic writings outside it. Original texts were no longer legally relevant. Interpretation became bounded by what the commission had chosen to preserve. This transformation raised a lasting philosophical problem. Roman law had once evolved through debate and interpretation. Under Justinian, that process was frozen. Legal knowledge was no longer discovered through argument, it was authorized through selection. The digest did not merely summarize Roman legal thought, it defined it, permanently, through the lens of imperial power. Chapter 6. The Institutes. Teaching citizens how to obey. Alongside the Codex and the digest, Justinian ordered the creation of a third text, the Institutes. Issued in 533 CE, the Institutes were designed as an introductory manual to Roman law, officially intended for law students. In practice, they served a broader function. They explained how the empire wanted its subjects, and especially its future administrators, to understand justice, property, and authority. The Institutes simplified centuries of complex legal reasoning into a clear, structured framework. Drawing heavily on the 2nd century jurist Gaius, the text organized law around basic categories: persons, things, and actions. Legal status, ownership, obligations, and procedures were presented as logical, orderly systems. Ambiguity was minimized. Competing interpretations were largely removed. This simplification was itself a political act. By teaching a single, standardized version of the law, the state shaped how legal problems were approached before they ever reached a court. Students trained on the Institutes learned not how to question the law, but how to apply it correctly. The text encouraged obedience to legal form rather than exploration of legal principle. Access to this education was limited. Formal legal training remained the domain of elite males preparing for administrative or judicial careers. For them, the Institutes functioned as both instruction and indoctrination, reinforcing the idea that law was coherent, complete, and inseparable from imperial authority. Through the Institutes, Justinian ensured that his legal reforms would reproduce themselves. Future judges would not remember the disorder that preceded the reforms. They would inherit a version of Roman law that appeared unified and inevitable, taught, from the beginning, as the only way the law had ever been. Chapter 7. Law meets faith. Christianity inside Roman law. By Justinian's reign, Christianity was no longer a persecuted religion or a tolerated cult. It was the ideological foundation of imperial rule. Justinian understood law as a mechanism not only for order, but for moral alignment. His legal reforms therefore absorbed Christian doctrine directly into Roman civil law, transforming religious belief into enforceable policy. Marriage law was reshaped to reflect Christian norms. Restrictions on divorce were tightened. Adultery, once treated primarily as a private offense, became a moral crime with legal consequences. Sexual behavior, inheritance rights, and family authority were redefined through a Christian framework that privileged monogamy, legitimacy, and patriarchal control. These were not abstract values, they were codified expectations backed by courts and penalties. Religious conformity was enforced with equal clarity. Laws against heresy were expanded, targeting groups such as Arians, Nestorians, and Monophysites when they fell outside imperial orthodoxy. Pagan practices, though already declining, were further criminalized. Temples were closed, sacrifices banned, and traditional rituals outlawed. Judaism remained legal but increasingly restricted, particularly in matters of public office and religious expression. This fusion of faith and law altered the meaning of justice. Legal disagreement could now be framed as moral deviance. Religious dissent became a civil offense. Bishops gained legal authority, while imperial courts enforced doctrinal decisions. Justinian did not view this as repression. He believed unity of belief was necessary for unity of empire. In his worldview, truth was singular, and law existed to protect it. But this certainty carried consequences. As Roman law absorbed Christian orthodoxy, it narrowed the space for pluralism. The legal system that once managed diversity now worked to eliminate it, replacing negotiation with enforcement and belief with obligation. Chapter 8: Immediate Consequences, Order, Power, and Silence. The impact of Justinian's legal reforms was immediate and far-reaching. For judges and administrators, the new legal system offered clarity. Where confusion had dominated, courts now operated with a defined set of authoritative texts. Legal procedure became more uniform. Appeals could be resolved by reference to the Codex, Digest, and institutes, rather than by navigating conflicting traditions. From the perspective of imperial governance, the reforms worked. Power, however, became more concentrated. Judicial discretion narrowed as interpretation was bound tightly to official texts. Governors and judges were no longer interpreters of a living tradition, but executors of an authorized legal framework. Legal flexibility, once a defining feature of Roman law, was reduced. Innovation gave way to compliance. Those who benefited most were the central administration and educated elites trained within the new system. They possessed the knowledge and access required to operate effectively under the revised law. For others, particularly provincial populations and minority communities, the system offered fewer avenues for challenge. Legal voice diminished as alternative interpretations disappeared. The reforms also strengthened imperial surveillance over society. Property rights, taxation, religious practice, and family structure were more easily regulated when defined by uniform law. Deviations became visible and punishable. Silence replaced debate, not because disagreement vanished, but because it could no longer be expressed legally. Justinian achieved stability, but it was a controlled stability. The law no longer reflected negotiation between custom, jurists, and courts. It reflected order imposed from the center. For an empire seeking endurance, this rigidity appeared necessary. Yet it carried a trade-off. A legal system capable of enforcing unity, but less capable of absorbing change. The price of clarity was constraint, and its effects would echo long after Justinian's reign ended. Chapter 9: The Afterlife of Justinian's Code. Justinian's legal reforms outlived the empire that produced them. In the centuries following his death, in 565 CE, much of the territory he ruled fragmented under external pressure and internal change, yet the legal system he authorized did not disappear. In the Eastern Roman Empire, Justinian's Code remained the foundation of law for generations. Adapted into Greek and incorporated into later Byzantine legal collections. In Western Europe, the influence of the Code followed a different path. After the collapse of imperial administration, Roman law survived unevenly through church courts, local custom, and partial legal memory. Its revival began in the late 11th century, when scholars in northern Italy rediscovered Justinian's texts, particularly the Digest. At places like the University of Bologna, these works became the basis of systematic legal study. Roman law was no longer imperial policy, it became intellectual authority. From this revival emerged the civil law tradition. Justinian's Code shaped legal systems across continental Europe, influencing concepts of contracts, property, procedure, and state authority. Its structure and assumptions spread through canon law, royal legislation, and, eventually, modern nation-states. Even where common law developed along a different path, Justinian's influence remained visible in legal education and theory. The endurance of the Code rests on its clarity and ambition. It presented law as rational, comprehensive, and authoritative, qualities that later societies sought to emulate. But it also carried Justinian's assumptions that law could be finalized, centralized, and enforced from above. One emperor's response to legal chaos became a template for legal order. Centuries later, courts and classrooms still reflect that choice, often without remembering the moment it was made. Justinian believed he was saving Rome from chaos. By fixing the law in text, he gave the empire order, clarity, and control, but he also changed what law was. Debate became authority, tradition became selection, power became permanent ink. Today, courtrooms across the world still follow structures born from that decision, not because Rome survived, but because its laws did. If you want to understand how ancient power still shapes modern justice, stay with this channel. Subscribe and explore the systems history left behind, but never took back.